Hello. Vicarious liability, page 705. I know you're tired. We'll make quick work of it. Best I can, anyway. I have something smart to say, but you're actually on time. Okay, what we're dealing with here is when actor A or plaintiff A is injured by actor B who works for for defendant C, defendant B, defendant C. In what situations will C be liable to A even though C has not acted negligently in any way, shape, or form? Okay? In the first paragraph, 705, respondeat superior, freely translated, look to the person higher up. Okay, let the superior answer. It's a more archaic definition. What's that?
More money?
Well, that would be part of it. That's my next point. I mean, there are really two sorts of public policies in certain theories, okay? There are loss distribution rules, and you'll see this again when you get to conflicts versus loss minimization rules. Loss distribution versus loss minimization. You have conduct regulating, otherwise known as conduct regulating rules. Okay. Primarily here, we're concerned with loss distribution. Why? Mr. Gunter, to your point.
Did you want to go after if you go after the person who works?
That's too plaintiffs oriented. Think objectively here. Policy, not going after. I know we're all plaintiffs' attorneys at heart.
You want to go after the bigger settlement?
So if we have if our plaintiff A, right, and plaintiff B is, you know, a lower tier laborer, okay, is it likely that that laborer is going to be able to compensate the plaintiff for whatever loss has occurred? No. Are we absolving the lower tier laborer for his or her culpability for the tort?
No.
No, we're not, right? We're simply saying that because the lower tier laborer is acting within the scope of employment for the benefit of the employer, defendant C, then defendant C should incur the responsibility for the loss that plaintiff A has incurred and otherwise may not be able to recover, for which he otherwise may not be able to recover. Notice in the middle of the paragraph, first paragraph, big one there. So, without exonerating the actual wrongdoer, who remains liable to the plaintiff and will be required to indemnify the other to the extent that he is able to do so, the liability is imposed upon both. Don't let me fool you. Okay? And then in that parenthetical there below there, it gives you the conventional reasons given for holding that the employer ought to bear the risk. And again, the primary one is that the tortfeasor here, the the agent, I mean, you have what? We've got three main categories, right? I mean, well, really, in the old language, it was master servant, which has been replaced by, you know, employer employee. And we've got what else? Principal agent.
Can you write a little bit bigger?
Huh?
Can you write a little bit bigger?
Can you listen a little bit better?
Yes.
Employer employee, principal agent. Boy, you did it. At the bottom, last line of the page, what the law does is to broaden the liability for that fault by imposing it upon an additional defendant who is himself without fault. That's the main thing. The basis of vicarious liability is that our defendant C, the employer or the principal, is without fault, but we're imposing upon them liability anyway. We're broadening the scope. So, what are the facts in Broussard v. Miniman? Oh, Rolana's still here too. Go ahead, Ms. Cockrell. Welcome back.
Thank you. In Broussard v. Minimed, Broussard was an employee of a pest control company, and she's working all day, breathing in these fumes and stuff, and she goes and gets into a car accident. And so the issue at hand is the employee responsible? She's breathing in the fumes and she was dizzy. And she got into a car accident. So the issue becomes, is the pest control company that employed her responsible for her being in an accident? Are they liable to the plaintiff who is Broussard? And, am I right?
Yep.
Okay. So,
There's a little bit more to it, right? Did she say she was leaving and she was feeling bad before she left?
she said she felt faint and dizzy before she left, and then she was going home, and if I'm not mistaken, they let her go.
They let her, that's right, they let her go. They didn't say, no, you gotta sit here. She didn't contravene any directive. She said, oh, I'll be okay. Okay, go ahead.
Yeah.
Safe travels.
Right, and so the question is that because it's foreseeable, or not question, the statements are, it's foreseeable that somebody breathing in relatively toxic fumes all day long could have a reaction of being a little bit lightheaded, maybe unable to drive, and therefore the employer holds some responsibility or some liability for this because they should have known this and they should not have let her go.
Right, and the key word there is
Foreseeability.
foreseeability, right? Because otherwise, what was the primary defense? Don't let it go. What was the primary defense that the defendant relied upon?
Defendant?
Yeah, the defendant, the primary defense, not the defense the plaintiff relied upon. Just let her go. Don't worry about it.
Hold on. I don't have my book with me, I haven't got it. I do not know. I'm sorry.
Cruz?
The defendant tried to say that they asked her several times if she was okay to drive, and she said, yes, I'm okay to drive. So they
Okay,
asked her,
Gunter?
The coming and going doctrine, she was going to.
There you go.
To her house from work.
And generally, what is the coming and going rule?
That when one's commuting between from work or to home, they're outside the scope of employment.
Outside the scope of employment because what? I mean, they don't really say it, but why?
Because they're not doing any work for the company.
That's right. They're traveling to and from work for their own benefit, not for the benefit of the company. Okay, very good. Second paragraph of the case, 706, under the doctrine of respondeat superior, an employer is ordinarily liable for the injuries its employees cause others in the course of their work. Respondeat superior imposes liability whether or not the employer was itself negligent and whether or not the employer had control of the employee. And then the loss distribution aspect of this, the doctrine's animating principle is that a business should absorb the costs its undertakings impose on others. We're distributing the loss that is the plaintiff's to those better capable of absorbing them. Yes? What? I heard somebody say something. Second sentence, next paragraph, thus acts necessary to the comfort, convenience, health, and welfare of the employee while at work, though strictly personal and not acts of service, do not take the employee outside the scope of employment. And we'll jump ahead a little bit down at the bottom. It is also settled that an employer's vicarious liability may extend to willful and malicious torts of an employee as well as negligence under certain circumstances. And the next sentence is that even though, okay, the company may set forth policy that forbids certain activity, that is not enough. Okay?
Such as drinking while on job.
Such as drinking, well, yes, that would be a great example, such as drinking while on the job, or driving after an excessively long shift. Okay? And going back to the previous sentence. So typically, right, principals, employers are not liable for the intentional torts of their employees as long as those intentional torts are not undertaken in the course of employment. Okay, the book provides in the notes upcoming, if y'all got that far, certain examples. The primary example that the book offers is what? Where might an intentional tort be committed by an employee, right, within the scope of that employee's employment, whereby the agent, provided that the general rule is that the employer is not liable for the intentional torts of the employees.
But drinking.
So under what, Mr. Francis?
Drinking, if they were DWI or something?
Well, yeah, no, that's more the negligence. Then you're talking about the negligence of the employer as well as the negligence of the employee. Yep, debt collection. All right? And in those circumstances, you can have IIED, right? And it can be, and the liability can fall back on the employer, A, if they countenance the behavior, or B, if it's ratified after it's been done. Ratification meaning like, oh, well, you shouldn't have done that, but we'll take that money anyway. Okay, what other context there's another major context that I like to think of. In what other circumstance is a intentional tort regularly committed in the scope of a particular type of employee? Think about it. Bounty hunters are independent contractors by definition. Yes? Yep, bouncer in a bar, right? Right? Forcible removal of a patron is harmful or offensive contact. Is it not? Okay? And it's also non-consensual for that matter. Okay? And so and in certain instances, bar owners have to be very careful about the people that they hire to protect the patrons, the not so unruly patrons. Okay? Because then you run into issues if the bouncers get too rough, right? Then who's on the hook? The bouncer and the bar. Yes, BJ.
But going to a bar, does that not
Is that not like?
Does that not consent to having your ass kicked on the way out the door?
There's a possibility. I was just curious, because we all know there's possibilities that when you go to a bar and there's a bouncer to act as orderly, they may have to.
BJ be throwing down when she goes out, you know?
If assumption of, wait a minute. Is assumption of the risk a defense to an intentional tort? No, thank you.
But it would be the equivalent of.
You're not consenting to being bodily thrown out.
Because
No.
you, that restaurant that you go to where they throw the rolls at you, if a roll hits you, you have consented to eating at that restaurant.
What? No, you haven't. We're going to stop right there. Okay? If you're offended by a roll hitting you, then you're hypersensitive and the rule doesn't apply.
Just don't go to Lambert's.
And if you eat that roll, then you have consented to battery. Notice, all right, settle down, all you punch drunkers. Case law has established a general rule that an employee is outside the scope of his employment while engaged in his ordinary commute to and from his place of work. All right, that's the going and coming rule. Don't forget that. Okay? That's first paragraph, top of 707.
Thank you.
If you didn't underline it already. But as Ms. Cockrell pointed out, the main thing to remember here, we're going to see it again in a minute, foreseeability, right? It wasn't foreseeable on the part of the employer that this person exposed to these noxious fumes might have trouble getting home. The answer to that is yes, and therefore, they have the employer has subjected itself to liability. Oh, you're going to be careful.
I'm going to be careful.
Okay.
In this position, I mean, if I were the employer, I would feel comfortable like making someone stay or taking someone stay. Like, what would an employer do in this situation to protect themselves from
Sure,
liability?
drive them home.
And drive them home, get them an Uber,
Okay.
I mean anything, but give them the key. Huh? I'm sorry, what? I still don't think that's enough. Documented it, nope. You can't hold them. You can give them a cab. You can have somebody else drive them home.
You know how much cab costs?
What if they just absolutely?
Yeah, I think under those circumstances, as an employer, you can say, yeah, you're going to stay here until you feel better. Well, then you have, then you can present the defense. Like, listen, we told her not to leave. We said sit here for 2 hours, or we offered a cab, or we offered an Uber, or we offered a ride home. Yeah, all of those were refused. Like, and then you say, Your Honor, we can't really hold her against her will. So at that point, we did everything we could do. And okay? Well, ask yourself this, Fran. What is the measure? What is the? What is the question that you would ask yourself? Right? If they've done everything that they can do to get her to stay, what would a reasonably prudent mini-med do in this same or similar situation? The problem with that is they're saying even though they didn't have it. But at some point you can't. You're right. You can't just hold her against her will. Right? Too much talking. All right, O'Shea v. Welch. What are we taking from this one? I've got 709 circled. Left side. Michael. O'Shea v. Welch. All right. O'Shea v. Welch.
The driver filed a negligence claim against the defendants based on injuries that were sustained in the car he was driving was struck by the employee's vehicle. district office to deliver sporting event tickets.
Chiefs tickets.
Yeah, came from a vendor. And the initial summary judgment was ruled in favor of the employer on the basis that no reasonable jury could conclude that the employee was acting within the scope of his employment. But afterwards, the driver, the employee and the driver's insurer entered into a consent judgment stipulating to entry of the judgment against the employee. And then the driver then filed an incident garnishment action against the insurance company which contested coverage under the employer's business auto policy. But the court found that the...
Where's all that? Where's all that?
This is what I read and put down. I have to look back at the thing.
From the book?
Yeah, the driver filed a negligence claim against the defendant.
Right, where's the garnishment? Just go on. What's the point?
Well, the point is that when he filed the negligence claim on the injuries that were sustained, the driver filed, well, yeah.
Just go on to the analysis.
Well, that's where I'm at right now, at the analysis.
So there are two things we're trying to take from this, Ms. Morris. What are they? Don't. If you blurt, I will throw you out. You will go home. Everybody's so anxious to go home. I will help you.
The
Yes?
interpretation of the policy's language in business and scope of employment.
Right? But there are two things that we're trying to take from you, right? So he was on, what was he within the scope of employment? And that depends on the characterization of what?
Well, if they found in your business to be unambiguous and interpret it to mean scope of employment.
No, there are two terms here. What are they? Arlana?
Like deviation law?
What?
The deviation law?
Yeah, the two terms that apply to the deviation are from
Right
the,
or substantial?
whether it's substantial, but there are two terms. Aren't those terms in the case? Yes, that's one, and the other one is, read? Detour. Frolic and detour, right? Frolic meaning what, Reed?
The latter is a deviation that is significantly related to the employment to fall within its scope, while the former is the pursuit of the employee's personal business as a substantial deviation from or an abandonment of the employment.
There you go. What page is that on? 709. Okay, a frolic is a substantial deviation such that what? Such that the employee has abandoned what he or she had undertaken for the employer to do something for his or herself. A detour is a minor deviation that does not interrupt the course of activity that the employee had undertaken for the employer. Here, right, the employee was driving down the road, saw a place to stop and take a break or something, right? And it was hit coming off the highway right there. What you're going, and then also on 709, right? You're given a list of factors to consider down in the penultimate paragraph. 1 through 6. 1, the employee's intent. 2, the nature, time, and place of the deviation. 3, the time consumed in the deviation. 4, the work for which the employee was hired. 5, the incidental acts reasonably expected by the employer. And 6, the freedom allowed the employee in performing his job responsibilities. As far as factor 6 is concerned, what was taken into account here? What did the court say about a managerial position? They've got a little more latitude, right? They got a little more latitude to say, okay, I got a minute, I'm going to stop here and check on the brakes. Okay? These generally, on as far as multiple choice questions are concerned, you know, you're going to run into situations where someone has borrowed a truck, okay, or they're on a delivery, and they go 18 miles out of the way to see, you know, their grandmother in the middle of the day and have a wreck on the way back. In fact, just the other day, President Riggers was telling me a story about a company he's involved in with employees' own vehicle was broken down. So without telling anybody, employee takes what is a significant piece of truckage, right, with a big tank on it and everything, delivery truck. And as he is driving to his house, he's off the clock. He takes the piece of equipment to get himself to his home. As he's driving off the clock without permission, okay, apparently the lug nuts on the left rear wheel of this rather substantial piece of truckage came off, thus spinning the truck in traffic. And of course, our not so employee is injured in the process, and then has filed what?
Lawsuit.
Nope.
Workers' comp.
There you go, workers' comp claim. So what do you do, right? Luckily, I don't think, as far as this particular chapter is concerned, no one else was injured.
Couldn't he be fired for that? He basically stole a truck, and workers' comp wouldn't.
That's right. That's the message. Keep it up, and I'll just charge you with stealing the truck.
So this would be kind of like playing basketball for PT instead of working out and then getting injured and then working on turning you down, saying it's not really part of your job to play basketball.
In PT?
This is
Oh, I don't know about that. What, does that happen to you?
It's happened to people.
Notes 1. There's frolic and detour again for you at the bottom of page 710. Notice this is almost always a question of fact for the jury. I mean, this chapter is full of examples, right, of different exceptions and illustration. Note 2 covers what we said that the court principal case covered. Employer cannot insulate itself from liability by imposing safety rules or by instructing his employees to proceed carefully. And then note 3 discusses vicarious liability for intentional torts. Bottom of the page, but when the employee acts from purely personal motives, he is considered to have departed from his employment and the employer is not liable. The appearance out of the first note case there, Manning v. Grimsley, about the Orioles pitcher. It was held that the jury there found that he was throwing the baseball because they were interfering with his job, and therefore they found that the Orioles was liable, if I'm not mistaken, or could be held liable. the one in the middle there, Mullen v. Horton, reversing trial court's grant of summary judgment in favor of religious order in case involving consensual sexual relations between priest, psychologist, and parishioner patient. Trier of fact could reasonably determine that sexual relationship with the plaintiff was an unauthorized, unethical, tortious method of pastoral counseling. Pastoral counseling. But not an abandonment of church business.
Not an abandonment of church.
I was not here in 96 when the Sanford case happened. Does anybody remember that? That was around in 96? No? It's right there in the middle of the page. The debate coach at Stanford killed one of his students, stabbed him to death. What's that? Yeah, murder is a major deviation outside the scope of employment. All right, important here is note 5, folks, okay? Negligent hiring, okay? In that case, that's not vicarious liability, right? Vicarious liability applies to the cases where the principal or the employer has not itself been negligent. In negligent hiring, not vicarious liability, because you're alleging that in hiring the individual, right, the principal or the employer has not acted as a reasonable employer would. Go back to the previous example. You know, a bouncer with multiple counts of assault and battery on his record. Sorry, what?
I said, or a school teacher on the sex offender registry.
That's right. And going back to my example about Applebee's last term, right? That awful example about the Applebee's manager down in Auburn who abducted the young waitress.
But I believe we'd only be liable if they knew about it, if we had past transgression.
That's right. If they hadn't done their due diligence, that's right. If there's nothing to find, then they can't be held liable. And there, in note 6, there is an Alabama case regarding legal malpractice. We'll take note of that. Anybody have any tissues? Tissues? Anybody? Thank you, Scott. You're gonna take my internal management. Okay, next subsection, independent contractors. What's the deal with independent contractors?
They're independent.
Go ahead, Colbert.
I said they're independent. They work for themselves.
I tried to knock him like that.
You just, you're off. You got an off switch? You got an off switch on her? What is it? Go ahead, pleasure.
The employer, the business is not only responsible to that a level of supervision for the contract, than it would be for a regular.
Well, let's flip that and say the only thing with which the employer is concerned with which the employer is concerned is the end product. Everything else that the independent contractor does, they can do it. It's not under their control, right? They can do it on their own time. They can do it the way they want to, as long as it meets the specs that the employer or the hirer or the contractor has laid down at the end of the day. Okay, then the contractor is as circular as it is independent, and therefore is liable in and of it only for the is liable for their own misdeeds, not the principal. Okay. Second full paragraph on 714. Second sentence, an independent contractor is one who engaged in to perform a certain service for another according to his own methods and manner, free from control and direction of his employer in all matters connected with the performance of the service, except as to the result thereof. The decisive test is the right to control the physical details of the work. The right to control the physical details of the work. This comes up all the time. You have to be able to recite that paragraph. Okay? You've got to be able to recognize it. You've got to lay out and make an argument one way or another, whatever the fact pattern may be, as to whether you think the defendant is or is not an independent contractor.
Is there any instances where that can be overruled in this requirement?
Well, we see in the following case, right? It's non-delegable duty, right?
Right.
Okay. There are certain things you can't entrust to other people. Right, you can go, and this is what goes back to what I said to Fran a few weeks ago. It's like, it's not strict liability. What are the facts here? Forgot. Yeah, the newspaper. Collections. Oh yeah, they got in a slap fight. Yeah. And we're 3 rungs down from the newspaper here. While last sentence on 714, while appellee established certain policies and standards to which all distributors and carriers were to adhere, such policies and standards do not rise to that level of supervision, dominion, and control over Gertz's day-to-day activities as to make him appellee's servant. I mean, while you guys are fresh off at MPT, I have seen an MPT. This is like fertile stuff for an MPT, because what the MPT writers can do, what? They can give you the statute, or they can give you some common law that defines, what the Franklin definition of an independent contractor is, and then they can toy with it just enough to make it great and make you make an argument one way or another. Okay? Note 1 just reinforces what we just talked about. Note 2 provides examples and exceptions. Maloney v. Rath, as I discussed again with Fran a couple of weeks ago, so here we had the brakes fixed. Defendant had the brakes fixed, the brakes failed. She said, well, it's not my fault. The mechanic didn't do it right. Okay? The question is so she can't delegate. We understand that she can't delegate the responsibility for the tires being, or for the brakes being right, to the mechanic. But does that mean the mechanic is off the hook? No. Okay? She can be and seek indemnification from the mechanic, but she's not off the hook, right? Yes, Mr. Francis?
I was just agreeing. I was saying, yes, they're both liable.
That's right. They're both liable. Notice again, back to our loss distribution discussion from the top of the class. First sentence, Justice Traynor. Unlike strict liability, Fran, A non-delegable duty operates not as a substitute for liability based on negligence, but to assure that when a negligently caused harm occurs, the injured party will be compensated by the person whose activity caused the harm, who may therefore properly be held liable for the negligence of his agent, whether his agent was an employee or an independent contractor. To the extent the recognition of non-delegable duties tends to ensure that there will be a financially responsible defendant, loss distribution, available to compensate for the negligent harms caused by that defendant's activity, it ameliorates the need for strict liability to secure compensation. Sorry, what?
What page was that one on?
Oh, I'm sorry. 716. I've got 716 circled, Ms. Morris. And then the next paragraph is examples of non-delegable duties. It's not an exhaustive list. And then you're given quotes from the restatement, sections 423 and 424 in the final paragraph of the page. Notice at the top of 717. Well, start at the bottom of 716. The responsibility for minimizing that risk or compensating for the failure to do so properly rests with the person who owns and operates the vehicle. He is the party primarily to be benefited by its use. He selects the contractor and is free to insist upon one who is financially responsible and to demand indemnity from him. The cost of his liability insurance that distributes the risk is properly attributable to his activities, and the discharge of the duty to exercise reasonable care in the maintenance of his vehicles is of the utmost importance to the public. That is the public policy argument behind the rule. Okay. How does the imposition of liability on the theory of a non-delegable duty differ from strict liability? Anybody? It's question number 1 on 717.
Strict liability is strict liability.
Thank you.
No fault.
Thank you, Ms. Colbert. I'm kidding. What? What is strict liability?
You're automatically liable.
What is strict liability? Not automatically liable?
dangerous activities or
No. What does it mean when I say strict liability?
Even if you weren't at fault and didn't do anything.
That's right. Liability without fault, right? Liability without culpability. Why is a non-delegable duty different from strict liability?
Got to have fault.
You got to have fault on whose behalf?
the person that can't delegate the duty.
No. Which in this situation, the mechanic, the contractor. There has to be fault on the behalf of the contractor. Okay? Thank you. 2A, there are certain responsibilities that courts will not permit to be delegated to an independent contractor, or rather, the duty can be delegated to another, but the responsibility for a negligent failure remains with the owner. The responsibility of a negligent failure remains with the owner. Skip a sentence. There is no obvious criterion by which it can be determined whether a duty is delegable or not. In the last analysis, the cases represent ad hoc decisions that, as a matter of public policy, one cannot avoid particular responsibilities by retaining someone else to discharge them because of the importance of the duty. Yes?
Example about the independent physician in the emergency room.
Yep.
So that would be, I'm trying to understand that because I've worked on cases where we've sued the hospital and physicians. So is it a physician that is volunteering time or like how would a doctor be able
I mean, that's fact specific.
I know, but I'm just trying to understand how a doctor would be able to practice an emergency room.
That's not the question. The question, oh, no, they used to do that all the time. Any anesthesiologist that you go to over here is at St. Vincent's does not work for St. Vincent's. They're their own anesthesiologist. Okay? Right?
Like they could have their own business.
Yeah, they're their own business that operates then and they're, but as the cases, as the note cases say, you know, if St. Vincent's, for instance, when I went to have my hernia surgery, if St. Vincent's didn't make it clear to me, right, that the anesthesiologist was an independent contractor, right, then there's no reason for me not to believe that that anesthesiologist doesn't work for St. Vincent's, and that's what the note case is. Okay. In fact, when and that's to your point, when I went in and was filling out that mountain of paperwork, I was surprised to learn that the anesthesiologist was not an employee, because I had never had major surgery. I only had this smug Vanderbilt general practitioner. And so, huh?
Your Florida surgery.
Yeah, but see, yeah, I was in no position to read anything back then.
I remember.
Okay. Apparent authority is something that you will learn much more about in your agency and partnership class next summer, not this summer. Okay, but one who expressly or impliedly represents that another party is his servant or agent may be held vicariously liable for that servant or agent's negligent acts to the extent of that representation. This result may occur even though the negligent party is an independent contractor, or even when there is no employment or contractual relationship whatsoever between the negligent actor and the party making the representation.
Like the doctor that took his friend to deliver the baby.
That's a good example. Like the doctor that brought his friend to deliver the baby. Okay, and so apparent authority, next paragraph, allows an injured party who reasonably relies on the representation to hold the party who made the misrepresentation liable. So then we got franchisors. And there, to your point, halfway down that big paragraph, Ms. Kafka, the theory also has been applied in cases holding hospitals vicariously liable for the medical malpractice of independent physicians practicing medicine on their premises. And then there's the note. Clark v. Southview Hospital and Family Health Center, right down there, Ms. Kafka. Notice in Note C on 719, there is a difference between inherently dangerous activities and abnormally dangerous activities. Do not conflate the two. Okay, when we spoke briefly about strict liability at the beginning of last term, we talked about blasting, or was that demolition or blasting? That was blasting, okay? And we know that The second restatement backed off the original nomenclature of ultra hazardous activities and now uses the term abnormally dangerous activities. Here we're back to inherently dangerous activities, and if you've gotten this far, you will notice that this note refers to the case, when do we see inherently dangerous objects? Before the what? No. Yes.
Was it the, I don't know, it was the, I remember it was the tire, but was it the snowmobile?
No.
Baseball.
No. Close. No. Keep all over the place. Mr. Siegel. No. The inherently dangerous activity, not the abnormally dangerous activity. What? The what? The golf club. The golf club. Remember the golf club that the father left laying in the backyard? It was one of the first 3 cases in the book. Whether the question was whether that golf club was inherently dangerous in and of itself, and we talked about the hierarchy from a hoe to a spade to a samurai sword. Okay. Negligence collateral to risk at the bottom of 719. That basically means that the injury arises out of a risk, or out of a consequence that was not foreseeable from the activity undertaken to begin with. Okay? And the example given here at the top of 720, affirming trial court's ruling the conduct of independent contractor crane operator in knocking a worker off a steel girder was collateral to the usual risk of operating a crane.
Does that mean that it was okay-ish? Like, that it was, I don't understand that.
They're saying that the risk of operating a crane is like dropping something inadvertently. Knocking somebody off something else is not necessarily foreseeable as an inherently dangerous activity. Notice D comes up. One who contracts for performance of an illegal act is vicariously liable for any damage, even if the agent is an independent contractor. That's a rule. Put that on a card. Write it down. And again, the last note 3 here goes back to negligent hiring, right? The negligent selection of a contractor. If one does not do one's due diligence in selecting a contractor, and that contractor turns out to act negligently and harm someone, then it is likely that he or she who selected the contractor can be held liable for that contractor's negligence. The important thing under joint enterprise, okay? Did anybody get this far? Yes. 2, Topka, Myers, Arlana, Cruz, Borelli, Felton, Legrone. I'm taking a roll. Hassan, okay? Morris. All right, we're doing well. Just checking.
Each member is considered an agent.
Michael, you're not on that list. Just so you know. Everybody but you, Michael. What you can take from Popejoy, okay, is what is on 721 after the break from the restatement, section 491. Okay, the 4 elements of a joint enterprise. This is, all right, so this is where this comes, I mean, this is the only place you're going to see this, right, in your torts class, okay? It might come up in some other context, but this is where you learn these 4 elements, and you won't see them again, and they may pop up in what is July of 2021 or February of 2022 when you guys get to the bar exam. Okay, so I may test you on it, but you're definitely not going to, you probably won't see it again for another 3 years. So highlight that little paragraph right there and make it a point to know it in 3.5 years. 3 years from today. 3 years and 10 days. Okay, here what the court determined is, even though there was testimony on both sides, right? They were arguing that since they were going to get the calf for the little girl, okay, they were trying to, the plaintiff was trying to get to the estate, arguing that they really weren't going to get the calf for the little girl, but going to get the calf for the parents, including the deceased father's ranch, okay, and that there was going to be a pecuniary, that the father would have had a pecuniary interest in the calf had they gotten there to get it. It's creative lawyering, okay, in a fine attempt, and really what happens is they fail to meet their burden, right? Am I right, Orlana? So we had a public accountant for the estate. We had affidavits saying that the father would not have had any interest in the calf that was to be purchased. Okay. And that the purpose of the trip was to purchase a calf for the daughter to raise as her own. It was not a joint enterprise. It was something that the daughter would have had for herself, not for the business. First full paragraph, 723, last sentence. Thus, it appears that only the daughter had an actual pecuniary or financial interest in the profits of the sale of the calf that was to be purchased at the time of the accident. Last sentence, first full paragraph, 723. Note 1, last sentence on 723. Because of these elements, each member of the joint enterprise is held to be the agent of the other. Each may therefore be held liable for the acts of the other. You got to get in the office?
I'll get notes.
Okay.
You have a key?
Yeah, go ahead and get Finley and let you in. Important is going back to 721 and the factors, the four elements of a joint enterprise. They're all equally important, but it is to point out an equal right to a voice in the direction of the enterprise, which gives an equal right of control. You're going to see that sort of language when you get to partnership agreements. Okay, that each partner has an equal right to control the direction of the business venture, the business enterprise. Venture and enterprise are generally interchangeable terms. But equal right to control is an important aspect. I would almost say it's more important than the others, but it's not really. I've got 1, 2, and 3 circled after that. Bailments, what's a bailment? We've got a bailor and a bailee. The bailor does what to the bailee? Colburn, don't do it. Oh, she's going to leave it.
Bails him out.
Huh? No, not necessarily. I'm not saying a bailor gives the chattel to a bailee, so the bailee takes care of it. The bailee does not necessarily damage it, okay?
Hold on.
Yeah, you hold on, like when you hand your keys to a valet,
Yeah.
your car is a bail. You are the bailor, the valet is the bailee. Okay, and here this, to me, because the family car doctrine has sort of receded into history, right? This chapter has been here for 10 years, and it's pretty much it's the same case with the same language, primarily that was there 10 years ago. The family car doctrine generally does not exist anymore, but under the family car doctrine, and there it is, in case you ever need to know what it is, on 724, the bottom paragraph. The family car doctrine places liability on the owner of a vehicle for negligent operation by a person using the vehicle with the express or implied consent of the owner for purposes of the business or pleasure of the owner's family. This is based in vicarious liability.
But this doesn't apply anymore.
It's generally been rejected. Okay, it's generally been rejected.
Is there a reason why?
Huh?
Is there a reason why?
Too much liability. I mean, it just doesn't make any sense, right? I mean, if you've got insurance for the 16-year-old and you've got insurance for the father, right? You don't need to impose liability on the father because the 16-year-old has insurance. See what I mean? And notice it's a question of fact if and when it does apply. All right. Note 1. A bailment does not make a bailer vicariously liable for the acts of the bailee and the use of the chattel. Under the common law in most states, a bailment does not make a bailor vicariously liable for the acts of the bailee and the use of the chattel. I mean, I think notes 2B, 2A, B, and C are self-explanatory. Interestingly, what is of interest in note 4 is the Graves Amendment as part of the Safe, Accountable, Flexible, Efficient Transportation Equity Act at 49 U.S.C. 30106A at the top of 727. That preempts state law that no longer can rental car companies be held vicariously liable for renting cars. There's a famous conflict case that involves just such a statute. And then, as the last note, here we go with negligent entrustment. Okay, so we've had negligent hiring, negligent contracting, and now we have negligent entrustment. If you give your keys to your drunk fan and say, go ahead and give me a pack of cigarettes, okay? That's not good, and that can even be if the person has a reputation, as the notes tell us, a reputation for being intoxicated.
I was gonna ask you about that. I don't know my brother got anything.
There you go. Just,
Is this for cars only still, or is it applicable to
well, I mean,
four-wheelers?
yes.
Airplane?
Yeah, no, it only, not airplanes. You can give the keys to the airplane to your drunk friend. Y'all are so tired, you're not even laughing anymore. It applies to everything, copy.
Okay.
Yes. Yes. Contracting and negligent entrustment. It's all the same concept, right? It's all about not allowing someone to do something who should not be allowed to do it. Smailage v. Westfall, imputed contributory negligence. Facts are, we have an automobile collision. One of the vehicles owned by Smailage was being driven by Westfall. Smailage was a passenger in the automobile. The other vehicle involved was operated by blank. Smailage suffered injuries in the collision and died. Smailage sued both the driver of her car and the driver of the other car in wrongful death and a survival action. I gotta make sure I say this right. Hang on. So the argument is what? That the contributory negligence, if the argument is this, blank was negligent and Westfall was negligent, and since Westfall was driving Smailage's car, right, that his contributory negligence, his negligence is imputed to her. Therefore, she was contributory negligent in her own death, and therefore, blank should get off. You see what I mean? You got me?
Should the driver get off?
Hang on, let me make sure I got it right. Blank, the other driver. Okay? Smailage owns the car. All right, we got, this is, art right here.
It's a good looking car.
Tell you what. So here is blank. Here is Smailage. Here is Westfall. This is owned by passenger. All right. Westfall is negligent. Blank is negligent. Smailage is dead. Okay? So since she is, the argument is this, since she is the owner of the car, right, his negligence in contributing to her death, his negligence, by virtue of her being the owner of the car, his negligence is imputed to her. Therefore, she was contributory negligent in her own death, okay, and therefore, as it with regard to blank is off the hook, okay, because of the contributory negligence rule, which contributory negligence means what? 1% responsible for your own injury, you are barred from recovery, right? That's contributory negligence, not comparative negligence. Yes, Mr. Gunther?
Does the court say that she, even though she was the passenger in her car, she let Westfall drive it, she was not in control of the vehicle?
That's right, right. I mean, we're saying this is the argument, all right? And they're saying that's the argument that is presented, and the court says all of this is wrong. Okay, so imputed contributory negligence, that doesn't work out for you. That's just the argument. So, first, next paragraph, bottom of 728. A plaintiff ought not to be barred from recovery against a negligent defendant by the contributory negligence of a third person, Westfall, unless the relationship between the plaintiff and the third person is such that the plaintiff would be vicariously liable as a defendant for the negligent acts of the third person. So, apparently they were either boyfriend and girlfriend, they may have been on a date, they could have been anything, right? But she certainly would not have been vicariously liable for anything that Westfall did in those situations, right? We're not giving any more information. She was not, in other words, Smalich was not Westfall's employer, right? You see what I mean? Y'all with me? Everybody with me? Golden, we good?
Yes.
Pleasure, you good? Frank?
I feel like maybe I'm overthinking, but would it almost be the same as if she worded the car and still let him borrow the car when we got an accident?
No, she's got to be in the car. You're overthinking.
Okay.
The only way that she would that his negligence would have been imputed to her is that, like, if she would have been vicariously liable for anything else that he did.
But what if she maybe didn't have a license and maybe she just gave me the keys, then she could be out?
That would change the complexion. That would be negligent and trust me, right? That would be negligence on her. That absolutely on her. That would not be imputed negligence. That would be negligence on her part. You see what I mean? Okay, that's a legit question. The only way she could have been held liable, or that her contributory negligence could have been imputed to her, is if she had been, his employer or a principal to his employee agent. Okay. I have seen that come up, so don't skimp on it.
They pay the car, right?
Yeah, the
The arguments that work.
yes.
Yeah.
Yes.
Would we assume in this type of case that the passenger is not doing anything to distract the driver, or she's just sitting there?
That's right. If she did contribute to the accident, that changes the complexion of the whole thing. Because again, just to Ms. Kafka's example, right? Then you're not imputing the negligence. That's direct contributory negligence, right? You see what I mean?
Yes, they just didn't give us very many details about why there's an accident, if there's an accident, and I just wondered,
Mine was in the interview.
what?
Okay.
Well, how come you don't wear my mind unless you're mine?
Because that's what Tiffany said.
Vicky, I'm not going to do it to you. All right, notes. 1. (1)(a), halfway down, the principal case was based not on the passenger-driver relationship, but on the owner-driver relationship. There you go. Last sentence, last couple of sentences there, Vicky. A passenger in an automobile can be charged with contributory negligence of his own if he, for example, grabbed the wheel, distracted the driver, or gave directions to turn the wrong way down a one-way street. I mean, you can read these other B and C for yourselves. Note 3 is important. Although largely abandoned, imputed negligence remains viable in a few areas. Contributory negligence of the employee will be imputed to the plaintiff employer. Okay? Fruitful ground for testing is note 4. When a claim is held to be derivative in nature, the contributory negligence of an injured party usually will be imputed to the plaintiff because plaintiff's claim derived from that of the injured party. That makes perfect sense. Notable in chapter 14, we'll stop after this first section. Who groaned?
It was,
Can't wait till y'all get to Professor Perkins next year. 6:45.
Hey, before you move on, was there anything that stood out in chapter 12 that we had to know?
Huh? Con law. No? I speak the truth. Con law. And very well. What's that? Only one.
You can change that for us.
No, I'm not, and never. I would never teach y'all con law, not in a million years. You could pay me enough money.
What, you just have enough of us?
No. I'm not teaching con law. No. Not getting down in those weeds. That's weedy. No. Funny story, a few years ago, D. Bushnell called me and asked me to teach con law. I said, call me back. Okay, this first section, I can boil down what you need to know in this first section in just a few minutes, okay? It doesn't apply to the owners of the animals. It applies to those who harbor, keep, possess, or harbor the animal. Okay, so don't think ownership is a deal breaker, okay? Second full paragraph, 734, landowners are not responsible for harm done by wild animals on their property unless they reduce the wild animal to possession or control or introduce a non-indigenous animal into an area. Okay? That makes sense, right? The black bear hanging out on the back 40 does not necessarily impose strict liability on the owner of the back 40.
The person who lets their 14-foot king cobra loose, like
What?
there's a person who handled exotic animals in Orlando, Florida, and he allowed a non-venom 14-foot king cobra to get loose.
Right?
He lost his license to handle exotic animals.
I'm sure.
I think they had to kill the snake.
I would hope. But the point is that if the non-venom 14-foot cobra had been already hanging out, then he wouldn't have been strictly licensed. That's what I was saying. Okay. Notice next paragraph. Develop the rule that the owner of animals of a kind likely to roam and do damage is strictly liable for their trespasses. And there is a list of animals to which this applies at the top of 735. Cattle, horses, sheep, hogs, goats. And errant fowl as turkeys. Common errant fowl. Gunter, what is an errant fowl?
A turkey vulture.
A turkey. Well, no, that's what I'm saying. An errant fowl as turkey. What is another errant fowl?
Quail.
A quail?
Well, it's a bird.
A turkey vulture.
Ducks? What's the definition? Somebody Google it right quick. This was pictures. What pictures of what? Stop, please.
The definition of errant is traveling or given to a traveling.
Given to travel. So ducks, quail, whatever. Not necessarily big birds. Okay, there you go. I didn't know.
It said there can be an errant.
Oh, okay.
Chase my dog and my son.
It says it can be a cow too.
Turkey's named Coyote.
Cow.
Fencing out statutes and fencing in statutes. You should make note of those. That's at the bottom of 735 and the following paragraph 736. Okay, the thing about wild animals, they give you a list, okay? Owners, harborers, possessors of wild animals are strictly liable for harm caused to others that is associated with the risk associated with that animal, right? Tigers bite. Snakes are venomous. And they bite. Okay?
We wrote a memo on pit bulls about this.
So, 737, the list. Lions and tigers and bears. Wild animals. Deer, yes. Bees, no. A boar, no. Okay? Further down. Customs of the community influence determination. An elephant in India, no. An elephant in England, yes. Camels, really no. Ferrets, weird.
What about emus?
Emus, those, I would say those, I mean, without looking up the case law, I would say those are, they're domesticated, right?
Domesticated farms.
Alpacas, llamas, as well. If they're penned, yeah, I think those you could, because, I mean, you can breed those, right? You have herds of those. And then there's all sorts of illustrations regarding zoos and whether they were kept in a cage on on private property. Domestic animals at the bottom of 737. Generally, the one free bite rule is a misnomer. Okay? Really what you need to look for is some sort of indication, this is a test question sort of thing, that the animal, A, is predisposed as a member of a certain kind of animal, breed, to be aggressive, or the individual specific animal has a predisposition to act aggressively. If little Fido has a tendency to sniff, then you should know that Fido is going to sniff at somebody. Okay.
Alabama has a leash law. It doesn't matter what kind of dog it is.
That's not what we're talking about, but yes. 739 deals with the dangerous propensity abnormal to a class. Notice, a large dog that owner knows has a tendency to fawn violently would be strictly liable for harm done by dog's playfulness or demonstrative show of affection. Yes?
When this is talking about domestic animals,
and dogs and things.
Is it, the evidence needs to be shown specific to that dog, or is it the breed, or is it general?
It's more likely to be specific to that dog.
That dog.
To that dog.
Okay.
I mean, y'all heard me talk about it before. I mean, I've got a friend who has one of the most muscular pit bulls I've ever seen. And, you know, her name is Sue, and she's about this big around, and it's all muscle, and she's just the sweetest dog on the planet. As far as I can tell. Right? Because if she ever latched onto my leg, they would need the jaws of life to get her off. Okay? And she scares me, right? Even though she's never growled, never moved aggressively, never taken a step in my direction or anybody else that I know, including my dog, right? But I'm like, no sir. Right? I'll pat her on the head from like right here. Hey, Sam. Thing to remember, right? And you'll see fact patterns that'll fool you. Okay, I'm telling you, they'll fool you. If you're running away from, if that snake got loose, all right. If y'all didn't hear, Mr. Gunter said there was a guy in Florida who had a 14-foot king cobra, de-venom snake that got loose. Oh, I thought I heard you say that. Oh, a fully loaded 14-foot king cobra. Yeah, no, I can still climb trees. I'll prove it to you. Let that snake in. All right. But the point is this: if the snake bit somebody, obviously you have strict liability. If somebody injures themselves running away from the snake, that is foreseeable. Okay? Even if you had a declawed tiger, okay, running down the street, somebody runs from the tiger, all right? Strict liability. If somebody trips, let's say the snake is loose and they're walking down the street, right? And they don't see the 14-foot snake, and they trip over the snake. Strict liability? No, because it's not the sort of risk that it's not associated with the risk that the snake is scared, right? Okay, so don't get tripped up on that. And we'll see next week when we start talking about abnormally dangerous activities, the same principle applies. Okay, the strict liability is only imposed for injuries derived from those risks that make the activity dangerous, make the animal dangerous. The size of the animal, like the violently fawning dog, the size of the animal is a factor. Okay?
It's mostly like whatever's reasonably foreseeable.
Yeah, whatever's foreseeable from the risk, but you got to focus on why is this animal a wild animal? What makes this animal scary? What makes this activity dangerous? Okay, next week we're going to see a case where there's blasting some miles away out in the Midwest, and somebody had a mink farm. And the blasting, the vibrations in the ground disrupts the mink breeding, and the mink mother ate her young because she was trying to protect them or something like that. And they tried to impose strict liability on the blasters 3 miles away. Didn't work. Okay, so you got to remember that we'll cross that bridge when we get there. And just because you're not strictly liable, right? You can fall back on a negligence theory. Okay, just because you don't have enough to show, this is the second full paragraph on 739. Just because the plaintiff doesn't have enough to show that that particular dog had a propensity, doesn't mean that the owner of the dog wasn't negligent in keeping the dog from harming the plaintiff. Okay, so what do you have to do then? So what does that mean? If you can't rely on strict liability, you have to rely on negligence. What do you have to do? You got to prove duty, breach, causation, and damages, right? If you got strict liability, you already have a duty. You already got the breach, right?
That's not the definition.
And then, if there's a statute, Negligence per se may come into play. That's on 740. Notice signs in certain jurisdictions make a difference. In Florida, a dog owner who displays an easily readable sign says "bad dog" in a prominent place in his premises is not liable in strict liability to anyone who is at least 6 years old. Apparently, it can. There is one.
Then in Florida, if you have a fence that says beware a dog, and you go inside that fence, that's wrong also.
That's right. It's on you. You assume the risk. That's right. I'm sorry. What? Y'all are talking. Yes, Fran.
What did you say? Did you say that?
Say it louder, Mr. Gunther.
In Florida, they have a statute that if you have a sign on your fence that says beware a dog, and you go inside that fence, you are at your own risk.
What if you're, say, a delivery guy, and you've got to deliver something to that house that requires a signature, you still take the risk? Do you still assume the risk of going to that fence?
No, that's the duty of it. No, that's the duty. That goes.
If you don't come out.
Just like when we
That's
go-
the duty's on the dog owners to come out and get that.
They have to beware a dog sign. What we do is tell the offender, secure your dog. If you don't secure your dog, because we can come onto that property without your permission, if you're on probation, if you don't secure that dog, we won't shoot the dog and you're going to jail.
All right. Nice job today, guys. See you later.
I have one last question.
Yes.
What for next week?
The rest of this and the next one. We're not going to get. All right, listen up. For next week, so there's no confusion. We will get through. Hang on. Just a second. We'll get through abnormally dangerous activities, and we will go to. Go through section 3 to 821, through 821 next week.